Yeah, I think it should be getting your children back and having your property be restored to you.
Sounds good to me.
And common law, yeah. So we probably should start out with a little bit of a definition of what's common law really, and how does that figure into the judicial system, and perhaps also just to tell a little bit of, what's going on right now and how did it get the way that it is, We have to describe probably to the average person a little bit what's happening with the judicial system, and how did it come to be that it seems like we don't necessarily have any rights in any of those courts.
Right. We have also the video already and audio from
the last one.
That was all about birth certificate and things. So this is kind of a continuation, but
that's really good.
More about actually
that's
the
really
court.
Good. Yeah, okay. All right, I think we can lead off here. All right, are we ready?
I've been ready for a while, and I'm so happy that you are that we have the top scientist of language to teach us all these what do we call legalese and whatnot.
Yes. Right. Well, it's pretty amazing, Lucy, because everyone would agree that if you never wrote any code, how could you understand that? And how could the common person really understand that? These codes, like legalese, are using words like the word person, which is not used a living being, but the word person is a word to describe a mind, a mental set, really, nor your corporate self. So you cannot define yourself more powerfully than saying that you're a man or a woman, and that you're coming before whoever it is as a man or as a woman. And so you don't have to stylize anything beyond that, really. And also that you could put that you're verifying the truth of this, and it's under oath that you're putting it forward, what this claim is, which in this situation we could be talking about how people could go about getting their children back, or how they could apply this to get back their property and their property to be restored. Common law, if we could just begin just to talk just a tiny bit so we could be understanding what the meaning of this is, it's really a codifiedness of practice of being, that's just the practice of our being, and the social patterns of the way that we ethically do things. And common law is, you're just not really doing any harm to anyone, and that if someone has been harmed, that then they can bring a claim, and so only someone who's bringing the claim has standing. So as a man is bringing the claim, or a woman, she or he has the standing, and you're the only one who has such a standing. The part of English law, the common law, is come out, but it's not just English, it's really the customs and the judicial sort of precedences and things that have come about over eons of time of the way that we practice. It's a part of the English law that's derived from custom, and the judicial precedent that comes from customs rather than statute, and it's often really contrasted with statutory law. Statutory laws and things such have come about because corporations have made these laws, and that may not be common law at all. So right off the bat, a person has to be able to know what court and how to go about doing things where they are if they were not in a court, for instance, that they had selected, which we're going to be talking a bit about. But if you found yourself in a court where someone else is really moving the court, you can still be eliciting your common law rights by bringing things over onto this level, which we'll talk a bit about. But the body of this common law or English law is adopted, and it's been modified separately by different states of the US and the federal government, and it's denoting like a partnership or a marriage, if you could say, by common law, which is recognised by unions, and it's created by mutual agreement more of how we all behave with each other, and not by civil or ecclesiastical ceremony. But the definition of common law really is just simply the custom and practices derived from those customs and the juridical precedents of our past based upon these customs. So if you have found yourself in a situation where you're not in a common law court, for instance, you could be in a court where it's only on a level of complaints and not a verified claim, and that because it's just certified paperwork and notarized paperwork, it's of a lower order of things than what it is where somebody actually has been injured and can point out that they've been injured, and they're making a claim for this. So as a man or as a woman, you have the ability to make a praecipe, and it's Praecipe, praecipe, which is an order. And you can make a praecipe as a man and ask for this order to be put into the rules and judgments and orders book by the clerk. And you could be asking for, if you have a claim, a common law court of record, and it's a trial by jury. And if you do, well, as you could, which might not really be, to have had someone against you as a man who is also verifying a claim that this didn't occur, or whatever it was, you only can have in a court such like this verifiable information put into the RJO. That's the records and the judgments and court orders and things, which the clerk of courts would write things into. The vast majority of courts where people are is not really a court of record, but everyone has a right to a common law court of record to be resolved on some issue, and that a person could bring forward a claim and put this claim forward. And so in the way that you could put the claim forward such like this, you can be, for instance, addressing the renunciation of some order that was put, perhaps that was not done right. You could, if you were in another part of the court, you could dismiss the court because you could be having a claim somewhere else. And it would be better probably that you're under your own bat where you are versus having other people decide for you, which we'll talk a little about. But as a man or as a woman, you're asking the judgment of the court by Praecipe, which is, Praecipe means an order that you're asking, you're requiring, because you're the only one who can require this, because you have a right. So you could use the word require, and you could use the word Praecipe, which is an order that is put into the court records to put onto the RJO, the Book of Records, Judgments and Orders. The claim, and it could be for a summary judgment that you have as a man, that the wrongdoers are in default, and that you can put this via Public Policy 7310 US Public Statute at Large 48,112, and this is a remedy to pay the man's debt via House Joint Resolution 192, or the remedy to pay a woman's debt via House Joint Resolution 192. So you're asking for that to be put into the record right at the start of the claim, and you can write a letter ahead of time saying that you want this claim to be put in and mail that in, so that the very first thing is right off the cuff is that this is a case which is being paid for, and you've opened up an Article 3 sitting in law or a Queen's Bench equivalent to what this is. And it's really typically a claim because your name, your trade name has been used wrongfully, and that there can have been a clerical error or even like a bit more intent in it than that, but which is a form of fraud by common law trespass on your trade name and by forgery, which is a form of fraud. And that, you as a man really have a verified claim, and you're standing aggrieved. Meaning that you're standing means you've got something that has to be done, and that something is not quite right, that you're the one who's standing aggrieved. To go back to 1865 Banking Act, people are sort of the trustees. All these government employees are the trustees of the people, and that you could be asking whoever is examining this to become your trustee and come from an office of trust versus profit. And so you're relieving them from having to prosecute you in any way, but they can't really do that if you're opening up a common law court of record, because no one else will have standing in the case unless somebody's moving a claim. So attorneys have no standing in this situation, nor does any other court worker really. What they can do is be a witness to the process, which that's what you're simply asking them to do. That's all. You could apologise if something had gone on, and that you were not being given a venue as a court of record, but you could be saying that you could be apologised that it is a basis that's being required by you to use this venue as a court of record, and it's not that the man is not being considered as equivalent to the king or the queen, and to be able to keep a jury to determine the right as to who has the ability to be able to tender an order on this matter. You see, you're going to find out if anyone else has a claim against you, which nothing is put into the court where you are there, which this would be like, if it were my court, I'd call it the jump court, that you have the ability to do that on this level. And so, I'd be saying that who has the right to tender or order in this matter of the jump court, meaning that no one else does except for anything that's verified. That's the only type of information, evidence that can end up in the file. And so it's just that you could be expressed wherever you are there in the paperwork that you didn't really give any entity the right to administer your property, and that it's been by a paper intrusion that trespass, common law trespass and forgery has occurred to you, and that you're simply wanting your property to be restored back to you. So if you just put this in a claim and keep it as simple as that, once the claim is in, then if you felt like you wanted to embellish a bit more, that was what you give out to the defendants to read, it's possible then to go ahead and make an amendment, put some amendment in and things. But basically it should be just kept very simple, that you really want your property returned back to you. That's all. And all this hoopla about saying that you've got this, you've got that, or make sure that you're being interpreted in a certain way. You just have to put underneath your name a man or a woman, and a line between you and the person who's the wrongdoer, not a versus. And you want to get away from words like plaintiff and defendant and things like that. Just simply words like a man, which you are, and you're bringing this claim forward as a man, and whoever else is hasn't done right, they're called just wrongdoers, that's all. And a line between the two of you in the space, which ordinarily would be the caption that goes on the front of any letter. And there in your letter, you're just really saying that, look, I want my property to be restored to me and be properly put under my control post-haste. If it's involving children or things like that, it's possible to be able to set a time frame that you want this back. And that otherwise, if time goes beyond, it's possible to charge the unlawful holders of such after 22 days of any suit having to be started, so you can cause some billing to be put that's really to do with your getting things done more timely, because this is involving a matter of children. And so just to recap just briefly, I mean, what you're doing is you'd be saying that I'm requesting, a court of record, and that I, as the claimant, as the man or as the woman is moving the court, that my property be restored to me immediately and exponentially, and that this is a matter of, if it's involving children, you'd certainly want to say this is a matter of exigence and spurious purpose, because the time frame that they can have been taken away is all sort of real injury, and you've got to go after that. But, what we've just covered is really something which would be the basis of a claim simply, and keeping it as simple as you can, like a page, it's just perfect, because it's just not anything else to really be decided. It could be said that that you could be got off your property be restored to you in a timely manner. It's possible for you to forgive whoever else has some debt of trespassiness upon you, because you just won't come in as a mendicant where you are. From Blackstone's commentary, Volume 3, Chapter 23, Section 378, there it talks about a trial by jury, and who can take the matter to a trial by jury. It's a common law of record trial, and then everyone has a right to have this as a venue, and though it can have not necessarily been offered to you, and the only thing that can have been where someone else was deciding stuff for you, which possibly could be not completely right at all, because unless you were understanding the code, you wrote the code, you're understanding all the legalese, it'd be better for you just to stick with common law terms, you see. So that have been shown to be more common law courts of record in the past was called the Queen's or the King's Bench, and today you can have a common law court of record trial by asking for this and by bringing it underneath your remedies for things to be paid, as we began talking about this. Under Juris Secundum, the volume 25, section 344, it says such that in a court in a court of record is not that which is to have to do about a fine and imprisoned for contempt. And so that's the type of court that you want, because you want to be who is in charge of things to be able to make sure whatever's needed to be is done. And so you're putting your name in the caption area where you're titling everything. You're putting your name above, and then you're putting the court below that in the middle, and then you're bringing yourself over to the left side where they will put, where you ordinarily would put, plaintiff and defendant, and they always have a versus in there. What you do is you put a man instead of a plaintiff, instead of defendant you put wrongdoer, and just put a line, because this is not a versus thing at all. And that's get you out of all of that. Basically, as a woman or as a man, you'd be just saying that you're pursuing this claim, and the court is not prosecuting the case at all. And that no testimony really, if only testimony that could enter into the court records would be taken under oath, it means that you've actually got to have someone else across from you. And in most of these situations, that's not going to be the case at all, because it's a fact that something wrong has occurred, like where people's children have been taken. It's because, as we were talking in the first program, this was all really to do with, by presumption of law, the state is having a big sweeping arm to sweep underneath its arm all who is seemingly abandoned. And as a result of that, because the claim wasn't made, they've just run ahead with everything, because no claim was made for the legal title to the children. But if a claim was made, then once that claim is made, that's what needs to be occurred, because that's not something which has occurred, which it should in this situation. And then there's ways to go about doing things to have your children have a birth certificate and all this sort of a thing, but for this to be cleared up right in the beginning. But for most people, it isn't, is it? Most people's mum had signed a birth certificate, not unwittingly, and signed away her rights, or our rights to our own body, by paperwork, and that a part of yourself, which is your all-cap self, is somewhere out there, which you are an authorised representative of, but you don't own that. It's just someone else owns that. And if you're only held to that, then you're just being held to your all-cap self and underneath some code. But you're the one who's presenting the case. So basically, it isn't a movement that's under the man's rules or the woman's rules. It's collapsed into the plaintiff. If you had already started out as a plaintiff, it could be just sort of said that you are requiring all of this to be put into a court of record, and that if anyone can have considered you to be a plaintiff, you are really the woman or the man, and that what you're bringing is a claim where the evidence is non-controvertible, and no witness, no testimony exists that's against you, see, as the man or as the woman. Because how could anybody, they'd have to verify that what's occurred to you didn't, and how could they do that? They'd be liable for that if they moved the court in any direction which was other than in the manner of protecting your property rights. So property really is what's exclusively yours to enjoy from all the other society members. And so, these are the relations that you have with your family. These are all the things that you can own, which are all more fictional. And this is what property is, really. And it's government is really formed to protect property. And, the reason for government is really to make sure property is protected. And that's the reason for government, really. What you're doing is you'd be saying that I'm filing a claim and that there is no witness against me, or show me the plaintiff against me, or verify a claim that's against me. And there's no injured party against the plaintiff who is penning this claim, this document. But you can say that you have a belief, because how can anyone verify that you don't have this belief? Or you can say, I believe that a false claim is being applied because there is no injured party that was existing by the plaintiff's hand, and it's lawful to be of one's own blood and title as far as children and things are concerned, and that I've come to have more of the common law of the land, and the man or the woman wants a trial by jury, that fraud in de facto be exposed, and that this claim that you're making, because it's of a common law trespass and because it's forgery, there is just no time limit or statutes on any of that. And as you make a claim, if you didn't go forward with that, your ancestors in many generations to come could even pick it up, you see, because there is no statute of limitations on fraud, and there is no statute of limitations on common law trespass on your trade name. There's an interesting case in 1985, Borrow Couples v. ORO versus the Superior Court, and it's all about inducement of fraud. It's quite a bit strange and funny sort of case, but the inducement of fraud under another's collateral is like fraud in de facto. A claim, it's just where somebody else can have been induced because they were underneath another's collateral. That's a type of a fraud, and that's certainly a type of fraud that's occurred. Most people's claims, a claim by a woman or a man standing aggrieved, and that you basically said in the claim that you're a man who did not have any contract with any person against whom he has a verifiable claim. And you have never done any business with any of these people. You don't even know them. Matter of fact, you're bothered because what's going on for you is that people are doing this who you have no knowledge of. And you could even say these things which I'm going about right now is just using common language to clear things up. If no contract was before the court, except the claim that you have there for you, to be restored of your property, and that the claim is about property theft and the return of your property, basically, you're not bound, and you can be asking that as in a question form, because that's really pretty wonderful, isn't it? Because whoever is asked king is sitting and they're the king, and that's called the asked king. So when you're asked king, you're not bound to any wrongdoers, and why should you be bound up to all these wrongdoers? You want that to be cleared away, and I want the wrongdoers gone from my life, and so, what we're doing here is we're just really putting things into a common sort of understanding, and making what you say very clear and simple. And out of what we go through, you'll come up with a little bit of a page which you put from the conversation that we have here. and that the conversation that we have, I'm doing what I can to cause you to have ever more confidence and awareness of the rights that you have. You see, you have a right to a common law court of record, and whereas an entity doesn't have a right, entities just have privileges, you see. But you, as a man, you have the right to be able to travel, and you have the right for liberty and to be able to be in control of your own property versus having had someone else sort of having been controlling that, as I said, by common law trespass and by forgery. But you could, as a woman or as a man who has this entity in your life at the moment, you're really requiring your property to be returned and back under your control. And then, you're just going to say I and your name, and it's okay. You can say like David or your first name, or that's all right. Or Jump David, claim that the wrongdoers have really trespassed on your property, and that the wrongdoers, wanting them to give back your property. Make it simple, like what we've been saying, and then otherwise you can charge $1,000 per day. If you don't give me my property back, you could say 22 days, because 21 days is one sun cycle, so if it's a day past, that's good. But you could say, give my property back, by 21 days of the time of this beginnerness of this suit. Otherwise, you can agree that, I've got charges, because, if someone has your property wrongfully, you just simply want it back. If it happens that if you get your property back, in time then you can forgive all the debt, you see, that the wrongdoers have, and that any claim that was not a complaint, you can forgive. You can forgive a complaint, certainly. You can forgive whatever someone else has done, but you simply want what's yours given back to you. Does not a claim, this claim stand true? You see, this verified claim, and that no claim is existing as we've been talking about the man or the woman. You're only making a claim, for the man or the plaintiff's tangible property, and then you can put the birth certificate number in there in brackets. And so you only need to relate to whoever this property is just by that. And the only other thing could be Exhibit A, which is a picture. That's it. Your tangible property, which when you put the birth certificate in there, number, and that which you have equitable lawful title of, because no one else has been able to come forward and say they've got a claim that they have lawful title, and that the wrongdoers have no verifiable claim against you. Which, how can there be a verifiable claim against you? You have to have someone who is a person to come up and verify that what you're saying isn't correct, if it wasn't correct, which this is correct. So how are you going to have somebody come up and verify that, you see? And no judge, no attorney, no one else has any standing in the case, because you're the only one that's moving the case. So you're the only one that's standing. You haven't been able to speak in these other trials that you've gone through, because they said that you didn't have standing. In fact, you gave all that to be represented by a mouthpiece who only had the standing on a level of a complaint and can't verify anything. So in all of those lower order courts and things, you cannot be necessarily really achieved on what it should be. But it's not a claim of custody which you could be asking existing in this case, and that any verifiable claim was existed that was against you, but yet none are. I think that you could be just saying right there in the claim that you're ordering the civilised proceeding is certainly not to force, where people could have been forced because of next story and time constraints on getting information in and things, which is very draconian and is more forcing. But you don't want any of that, and you can set your own rules of the ways to be, how things might go. But you're basically asking that we've been talking about that you're a man, you're simply a woman. You can't define yourself to be better than that. You're verifying this claim under oath and affirmation. And don't you, if you could be asking them a question like this, don't I have a common law right to have a common law court of record by jury by trial by jury, rather than jury trial or trial by jury, which is different. Because you're the only one who has a claim and is standing upon a valid foundation. It's something which also could be said. You're the only one that's there, that's standing upon a valid foundation, and you're simply asking for your property to be back, given back. And you can forgive defendants and talking down. Otherwise, if it continues on, it's possible past these 22 days of the year they've started some claim, you can be charged $1,000 a day of damages that can be inflicted for anybody who interfered with your claim. If no response, if there is no response, you basically have acquiesced to what the terms of this notice is. So it's just possible to put this in a notice and not to use any other terms to define what this is. It's just notice in capital E and everything else in lowercase. Even the descendants, as we were talking about, once you have this claim, it's not latched, you see. You're, as a man, and as the plaintiff in this case, it's not latched. Yet the defendants or the wrongdoers have certainly got a constructive trespass, and this you can be asking things in a question like, can you agree to note? But this is not a notice to you as me, as a man standing aggrieved of a constructive trespass upon my property. It's better to put it in terms of that. Whereas on or before such a date, you could have made some error for you been requesting a trial by record, a trial by jury, a common law court of record. And that's what we're really sort of wanting you to, as you're viewing and listening to this today, to have a deeper awareness into the benefits of having a proper venue for things to be decided versus a judge deciding something for you. So basically you just really want them to remove their property from your property and remove all trespass on your property in this matter. And you want to have your property be restored back to you under your full control. And you can continue, of course, with things which is more, can you agree to note, because that's something which you're really asking someone to respond back to. And if they don't, well then they've acquiesced to, what this really is. Phone calls are all useful, aren't they? And talking in court and things can be not so useful necessarily. You always can ask for a leave for a moment to answer something. You always can come back with a note which just says, written, please restore my property to me. And you can ask someone else to read that into the record. Or what's this got to do with my property being restored to me? I want my property to be restored to me immediately. And be bringing it always back to a common law more wherever it is. But if you always can put something into writing, and you can always ask whatever is going on there to be put into writing as well. because you should have some logic to have gone on, or if. But in most of these situations, it's going to be resolved really so bloody quick, because they're going to be coming up against you, and no one's going to say that this property is not yours when it is. It's this claim not being required to be in a common law jurisdiction of the land. No ordinance, no time limit. That's what we're talking about. And is this not a woman or a man standing aggrieved? And is not the court, the woman's court, the man's court, where a forced instrument, that's what we've been talking about, can have interfered with your property rights. You see, that's what's happened. These forced instruments have interfered with your property rights. And this is not a simple claim of wrongdoers interfering with your property, with my property. Is this not a man's claim? Of course it is. Not another's interpretation. Of course it can be another person's interpretation. But underneath it, if it was just filed as a complaint, which most, or 98 or higher percentage, is actually just today being filed judicially as a complaint, and things are only being served on the level of being certified or notarized, it's like, this is really, really weak, because you need something more verified, because you're standing behind what you're saying. And then not another's interpretation. Is not common law, is this not really common law trespass and forgery in a case about these things, really? Keep it simple. You're saying, I'm verifying this to be true as a verifiable claim of forgery, and that this is, we're talking a verifiable claim. I've kept saying this, you've got to make sure that you're saying that this is a verified claim. You're accepting any verifiable claims, and you're not accepting anything that's certified or notarized, only something which is a verifiable claim. So, yes, that's the type of evidence you're asking for, because you are verifying, not just certifying or notarizing, and the man doesn't understand any inconvenience of, or the woman doesn't understand any inconvenience of not being the person who wrote a code. So why should you be held to be underneath that? Something which is a bit inconvenient for you because you never wrote the code. Why should you understand that? So you really want a common law court because of this. You see that would cause, you just don't want to be inconvenienced by a code that could cause you ever more harm and trespass. So the trespass really is admitting sort of property, administering property without any authority to do so. That's what the trespass is. So there's the administering of property that's really without any clear authority to do so. Questions could be considered like, has not the man been ordered to do such? If you have, well then such a public servant's orders can be carried out if there isn't an order. And so they're asking for an order, and that order could be signed by a man. If that's so, then it's possible for you to charge, because they're ordering you to do something and you have the ability to charge for that, just like anything else. But who's the man who wants to make a verifiable claim against me? That's what the question is, because there isn't, you see. I'm requesting everything to be put into writing, and that any question that is asked of me, if possible, it's better that you say, look, just let me take leave for a moment to write this down, and I'll hand it in. Because you have rights in a common law court, but in another court, type of court, you only have the privilege to be codified and have someone else being deciding all that for you, which is just not going to be good, generally, except if it's simple sort of matters, maybe. But whoever enters a plea on my behalf, for instance, it could be put into your letter, is this not that this person is bearing a liability if injuries existed because they've put my behalf, anybody's putting in pleas on your behalf, they bear the liability. Who bears the liability for if something happens to the children? That's a question. Because who has the legal title is really bearing liability. But where the man is of you're really of your unlimited liability, and all corpse is only of a limited liability. And the Virginia Supreme Court ruling, that's like a V and an S and an R, Virginia Supreme Court ruling, 7B2, that sort of right there says that you as a woman or as a man can't be compelled to fight, and as none is of any harm by the woman's action or the man's action here moving his claim, and only all else is really just an advisory code. So somebody says you shall stop. That's the word shall. That's sort of something into the future that you would stop. And so no one's ordering you to do anything. But if they did, then sign this order, and you're the man who's signing it, and then this is the person who's becoming liable, you see, to have interfered with any claim that you have. But it's just not. It's not this sort of spoken in common law that someone who has not been done wrong by the plaintiff, which the wrongdoers generally has not been done wrong by you, and yet it's not time of essence and of the matter of a case or of a claim involving fraud and constructive trespass. So you're sort of really speaking with your claim on a very simple level of fraud by forgery and common law trespass. And there's not anyone who does not have first-hand knowledge. They don't have any ability to be able to speak about anything, you see, because they just don't have first-hand knowledge. So it's a totally different way to get things done. Most people in every other situation could be speaking like crazy because they don't have any first-hand knowledge. And if they do, then you'd want them to be sworn in to verify such claim as what they could make, because then it's possible for you to hold that person liable because they could be lying or not really be aware of some code or something. Which generally, where is it? Just locked up somewhere, and there's some code that's come from it, but that's not even the law necessarily. And if you ask for them to bring this into the court and explain, vast majority of people are not going to necessarily really be able to do that at all. And in a common law court of record, it's just no code or statute or things such like that. For the man is here, or the woman is here to by Praecipe, require the court to award the woman or the man back his property, and is not this woman or this man of a trust of the public law. Entry of any forced paperwork, which we've been talking about calling this, and forced intrusive paperwork that involves forgery to trespass constructively on the woman's or the man's property. And so is there an order? You're just asking, hey, is there any orders? Because I'm ordered, if you've been ordered to pay, again, to collect a debt, why not just say that? Hey, listen, are you ordering me? I've got to go and pay, got to do this all more again, or I've got to do something just simply to collect the debt. This Queen's Bench and King's Bench always was open to the King and the Queen at any time of the day, 24/7, and is free as to you, that you put things on the RJA like we talked about in the very beginning of this program. And you can even caption that So that's really clear that you're giving messages to courts to enter this in under the public law. That's your remedy to have any debt paid. Otherwise, you're just asking, does the court want to tender me a lawful bill that I can accept that you've signed? If there is any order, well, that you have a right to be asking them to tender you a lawful bill. But if this case is moving under the man or under the woman aggrieved, who is the driver of the claim, and that the court really isn't in this situation what we're talking about. In most other situations, the court's going to be driving the claim and driving the treating crazy, probably as well. There's no such thing as a statute of limitations we're talking about where fraud and where trespass existing. And you're just asking the minister there, of course, out to assist, protect the claim and not maintain a position, but that man is unlimited in this trial by jury, and an entity really is just of a limited liability. So in ecclesiastics, you only can join like with like, Lizzie. Right. You can't join what's not like with what's not like, you see. So that persons in our first program that we did with each other, that you can listen into this, you'll be able to get a sense that, a corpse can only be joined with a corpse, and a man can only be joined with, a beloved can only be joined with another beloved. And an entity, as we're saying, is just really of a limited liability, whereas you as a man or as a woman have unlimited liability. Because no man or any woman can have ever made a claim against you, there is no verified claim against you. You can say, listen, I've got no idea about codes, and it's only who had a claim, yet no one has a claim against you, you see. So this is a matter of a verifiable claim of a non-controvertible matter, meaning it just can't be controverted into anything else. It's non-controvertible. It's a non-controvertible, probative, documentary evidence before the court that the matter that would ordinarily be a claim is really a claim, so it's a simple summary judgment. I think that you might be sort of getting the picture a little more. Otherwise, lots of things could be struck that ever you did put, because anybody could say that it was unauthorised, procedural rules of filing and all sorts of stuff which you never made, those bloody rules, and they're thick as the hair on a cat's back. It's going to be not easy for anyone underneath that, and it's been perfectly designed just to control you. But you can have, doesn't matter what's going on, if you're keeping things as simple as what we're talking about here, you're going to have success, you see. And that's sort of really what you want. And of course, you could be saying, I'm giving you fair warning to stop the fraud by ad indefactum, and the constructive trespass by dragging you into their wrongdoing, or dragging you into any of the wrongdoer's doings. And where's the law of 1776, which you have a right to a claim? Well, you might use whatever to a claim, even if it's just for pennies, really. Article 1, Section 10 it really talks about how someone as an entity can have, by constructive trespass, taken a man's property wrongfully. And any beloved who is standing aggrieved has a right to bring a claim. And you could be bringing a claim against the wrongdoers who really can have no real standing because they don't have a claim against you. The man is or the woman is by a Praecipe, requiring the court to return the man's property within a certain time, like 24 hours, might not be quick because, this stuff can have really dragged on, but you could be forgiving the debt. So it's possible to get things done quickly, or you just put a time frame in there that can make things fit. If some wrong was done, and you could have pointed out that someone had interfered with your claim, you could say that you're making this part of the claim, and that because wrongdoers clearly have intruded and interfered with your claim, you'd be putting this forward in this claim that you have. Otherwise, that this can be cleared up, this matter straight away, within 24 hours. Otherwise, within 22 days of having to make a claim that this is not settled, that the wrongdoers agree that you have a right to be able to charge, because it's sort of like an ordering you to do something beyond and spend more or cost you more, where you are the one who really has a very viable claim. And entities might have a complaint, which that's just a lower order. You could make a claim about that complaint. But I'm making a simple claim, was really saying, and I'm asking for my property to be returned. I keep going over that because that's all that you really need to make this about. Because there's no controversy for them to be deciding of anything. You can see not a capacity to understand what wasn't ever created by you, meaning that how could you be understanding or be held to any bloody code that you never created? The man didn't write, or the woman didn't write the code, and is it not your wish, as a woman or as a man, it's not your wish really as a woman or a man to be involved in anyone else's code, especially where that could cause you harm and stress, which that's the reason why you want a common law court of record, trial by jury. And I know you don't want to be a source really of harm. It's probably a good thing to say, because most people don't want to be a source of harm. It'll all be gone against the customs that prevail and the laws that are underneath this. And as we've been saying, the question, is there any other claim that's existed? Of course there isn't. So if nothing is entered into the court by a certain day, you're giving notice to the court that if there's no verifiable claim, even any complaint exists, but there's no verifiable claim, you want your property to be restored to you, and by Praecipe require of the clerk of courts to enter into the court RJO a judgment in your favour, and then that can be taken down to the sheriffs to get a sequestration for your property. It's not a simple constructive trespass and administering of property that's going on. I'd say that's the case with most everybody. and we're giving notice of invoking a common court of record, trial by jury, and that you're basically saying, hey, listen, I'm a man, I'm a woman, I have rights, and all else have only privileges. And in commerce, my name is, my family name is Judd, and people call me David, and that the wrongdoers are administering my property without any authority to have done so. As a woman or as a man has a right, and that only duties and responsibility and privileges are under that, and only an entity does have duties, responsibility, and privileges, and that I have a belief that I have a right to my property, and all I know is a man or I'm a woman, and is the court's written response a complaint? If it's not is the court's written response a complaint and not a man's claim, meaning that you're only wanting what is verified to be in front of you and not some complaint, which is a very low order type of reasoning, because nobody's verifying that. They're just sort of going along and saying, I think that you did this, and will you agree to it or something. But if you've done what you can to settle this claim in the private, by having written a letter like this to anybody that's involved, and they just never really did anything, that becomes non-controvertible evidence. So you don't really have to do anything. You could just do it like what I've just said here, keep everything simple, and go ahead and file a claim in a common law court of record. Yet you was filing this claim against, is it not you who is filing a claim against, is it, where somebody is, wherever they are, they could always be asking, who is it that's filing a claim that's against the man? No one would step forward, so simply be dismissed, because where's the claim? There isn't. Having filed a verifiable claim as a man. And I've been, if let's say that you've been entered on the wrong side necessarily of the court, that they put it down as a complaint versus a claim, verifiable claim, which is on the right side of the court, it could be said that you've talked to the clerk, or you put the clerk on notice that something has been filed in error on the wrong side of the court. If it didn't go on the proper side, I need you to move me over to the common law side of the court, and it's giving notice to someone like the clerk that could have filed this in error to have moved your claim from the complaint side back to the claim side, and that this of itself is a matter of trespass, and possibly it could even be by error or actually in bad faith, but the wrongdoers would be liable because they entered something in to force some situation, and they'd be liable for injuries to you, and also having interfered with your claim. So it's a notice to the court to move from the complaint side of the court to the claim side, and then putting that preamble that we began at the very beginning of this talk, by making sure that it's listed there that this is being paid for. So it's a simple trespass, and it's just really personal harm that's going on for you, and that's all occurred because of forced instruments that has injured you see. And just sort of keeping it very simple like this, and I think that I'm giving you ways to go about writing a page, really, and hopefully at the end of this, some language is stuck with you, and you've got something out of it, which any of it, and even just a few sentences of it, is all that you really do need. You don't need something elaborate at all. Simply that you can put your claim in first up, the better off it is. And then if you want to modify it afterwards, that you can. But you can agree that the man doesn't want to file a claim against any complaint that was, if you were being held on a level of complaint, you're saying to anybody there that you don't want to have to turn this into a file of a claim against the complaint. And this is to be by Praecipe to have this claim put into court record, the Book of Judgments and the orders, as indicated herein in this notice, and that it's for the ease of filing purposes only, and this just doesn't have any impact on denying whatever's gone on inside what the case is about. It has nothing to do with that. You'd be saying that I don't want to have to interpret your system, for nothing such can deny my claim as being verifiable truth, and that this is my property that I want, and I want this to be restored to me, and I can forgive debts of the wrongdoers, and having administered my property without authority and right to do so. But it can be agreed that because such be a simple verifiable claim of forgery and trespass on the man's property, that the filing and that the filing of the claim has no impact on the file document. If there was a file document on the wrong side of the court, because you could be just asking them to bring it back on the right side because you just found this out. But the man is moving this to be on the claim side of the court, and that you're giving a notice of a Praecipe, which is an order to the clerk of courts to place this claim on the right side, and that you're noticing that it cannot be put on the wrong side of the court. It's because it's a trade name claim of trespass, and it's a simple return of your property, and that you've identified the wrongdoers who've done you wrong, and you could be listing those, the wrongdoers, and that the man is harmed, and that his property would not be returned, and this is just simple common law, and that the man is abided by this as a court of record, and that you have as a man or as a woman a right to such a trial by jury, and it's not the court a simple witness that of the judgment, and that's all that needs to be existed there. As long as there is something that's in need to be simply settled, and that this needs to be simply settled and done so by your witnessing, of such. Yeah. Otherwise, because no conflict is before the court to move into any barratry, you don't want them to enter into any barratry by saying that you don't want them to enter into barratry. You don't want any conflict to be before the court, and you don't want them to be moved into any barratry because they have no voice and have no standing as an attorney in the case or any court worker. But no law binds you to the wrongdoers, we were saying, and that these are people who you don't generally know, so why not say that? And I don't know how they have entered into my life only on a false claim, and that I, David, or I, Lukey, or you put your name in there, claim that the wrongdoers have been trespassing on my property, and I want them gone, and I want the delivery of my property back underneath my control, my jurisdiction, within 24 hours. If something has really gone on that's really been interfering with your claim, go ahead and just put a time frame in and say, listen, I want this back right now. And I can forgive no law, no contract that binds the man to his the property. So you're not going to forgive any law or any contract that is binding whoever else it is to be having held on your property. And that, we've been talking about you saying that as a woman, as a man, that you're placing a charge of $1,000 per day per said trespass on the said days, which could be like 22 days from the 22nd day onward, after having to file a claim because they're not giving you back your property. If placement of all said property does occur on or before this date, then you're simply saying that I forgive those who trespass of their debt upon my property, and that I care to be forgiven also in a similar way. I think we're sort of getting close to perhaps getting to a point where I think it's possible to be able to write a page up from what I've said here, and that it's possible for people where they are to really be able to have a better sense of what their rights are. Anyone who has anyone asking about their children, or they feel there's a threat to the children, it always can be said, show me the legal title. And if someone can't show you the legal title, well, if they got any right, you see, to order you around, nobody can look after your children better than you can. All children who go through, all this sort of punishing times, that end up with sort of stress. It's not boding for a very good society. And these court systems are similar to just like any report of spanking, which is wrong. All corporal punishment is wrong. And we shouldn't be accepted of anything such, because when you are living in a society which really causes you to be able to have the means to be able to resolve things without violence, and you're able to settle and create resolution without conflict necessarily. But it is amazing, that 90% of Americans report spanking their kids. That's pretty high. America is quite high with spanking their kids. There's 3 generations of kids that's passed by where children haven't had a father, which that's very wrong. The reports show that even 14-year-olds can be being corporally punished, and that 90% of people are beating or hitting their children on per week 3 times, at least a week. You should have a little bit of a look into this, but we're living in a world where people can have been disempowered, the beloved can have been purposely being disempowered by a system of secret weapons for a quiet war, and where the parent becomes stressed. Of course, they're not as able to manage things, and they're more likely to sort of be involved more in controlling the children, which statistics show that these are kids which are not going to end up necessarily very well generally. But 62% of all parents even hit someone who's a toddler, and someone who is only 1 year old. 62% of people have hit their 1 year old child. 22% of those that are punished with, and 22% of the time, it's reported that kids are being punished more with implements, like canes and burning handles and things like that. 91% of children, 91% of all boys are battered and corporally punished, and then there's a smaller percentage of girls. But then that's sort of starting to rise a bit more as well. In the past, it's still very sexist that boys are beaten and you're beaten because of your gender. That's wrong. But 91% of all boys and a smaller percentage for girls are beaten, you see. And are parents sort of really doing that because they have generally lost composure? I'd say that's part of the secret weapon for a quiet war is that you'd raise people that really would end up sort of being more drongos, really. 93% of the people, when they're surveyed in America, they justify beating or spanking, which spanking is violence, and it's calling it spanking versus being corporally punished. I think if you've spanked 3 times in a week, it might be considered actual corporal punishment or something. But it's just when somebody doesn't have composure themselves and they have done things to others, which that's what this judicial system is doing at the moment to all of us, you see. But there is open to you because if you listen to the first program, it's really all about how money was taken away, and because no money existed for a proper trial, all that ended up happening was a trial by a judge, you see. And that was being done to you, and money's being made off you. And so it's possible that bad faith could have been incurred, that you weren't entered onto the court on the right side, especially if you cared and made much motion that you were caring to make sure that you were in a court of record. But 93% of the parents that are doing this justify it. And then, in the same survey, when you're asking them, is it possible that they could have gone a bit overboard, more than 50% report to say that they certainly have gone overboard in times, and 85% of these people say they would not rather do that in the way that they did, and that morally half the parents say that if something could be done in another way, they would have, and that half say that typically that they can never have overdone what they did do. This leads to all sorts of increased risks in poor relations later, and obviously for you getting your children back, because the state is certainly not a parent, and an entity can never ever be a parent, and a parent can be thinking about the children in a way of being which perhaps others might not, and I think that's really kind of fairly well understood. But where he can or she can just not have a relation with a father, people can be tend to be very poor at being able to relate later on in life. And this puts risk on children, and that those kids can have become more aggressive. They can have hit or even not been necessarily friendly to other kids, and being aggressive and bullied if they were bullied themselves. And so to show that kids that grow up in a world like that we've been talking about, they have damaged sort of mental IQs and lower IQs, and in countries where they punish children ever more, they have a lower IQ, and in countries that don't punish children, far higher IQ. Yeah, so anyway, I just thought I'd just add a little bit of that in there because, a lot of injury and irreparable harm and damage has occurred, and in my mind I feel issues which relate to your children, you really want to be able to get them back straight away. Yeah, not have to really wait around. You want to correct the stuff that's going on as you can straight away. And anyway, what we've been talking about is a way for you to be able to, get this done more quickly and more efficiently. And terrorism, you'd agree, really is interference with proper forms of government. And if you've not got the ability to govern your property, well, then that's a definite form of terrorism. Terrorism really is where there's an interference of the proper forms of government, and where property rights are being interfered with. And I'd say that the judicial system, where it is having taken people's kids wrongfully, we could say a system is existing in which most can have not necessarily really had to go through, or if they did, they went through a bit of it and never had to know more about whatever else. But it might be only upon that that you all of a sudden realise that this is really, really immoral and wrong where you are, especially when you don't have a voice. So where your property rights are being interfered with, that certainly is terrorism. And terrorism is wherever there's an interference with proper forms of government. And how can you have proper form of government unless you have informed consent? And how can you have informed consent without a currency which is constitutional? And these things go hand in hand. Unless you have a currency which is constitutional and you tick the box, yes, you want reform in banking, a lot of these things will all be corrected. And so they should be. And worldwide there should be really a moratorium, which is a breathing, just saying, hey, listen, I think you should take a breath and learn how money is created. And then upon us having constitutional money, it's possible for a lot of things to become corrected. At the moment, really is in really a state of decay. And there's no question about it that we all are allowing sort of a hand to exist about the government where a monopoly exists, and that monopoly has created rules for themselves, and that's just to have goats that might fall over because they're so bloody frightened. So that they're all picked up, put to the back of a pickup, the farmer takes off. Only a few minutes later, the goats wake up. They wonder what's going on. You see, stock is sort of being bred more like that, and all this social engineering is very, very wrong. I personally think that people should be left alone. They should be left alone to be, and that all social engineering is very, very wrong. And we've got challenges in our society at the moment, primarily because we don't have a currency which is based upon love. And as you're the bank that this current comes up against, that's how it should be, and everything else in nature as well. But when a private person took that away from you, then they became the bank, and you weren't. There was no bank for any current to come up against you. We need again to have constitutional money. So anyway, I hope our talk today has been useful to you, and that if any questions exist, it's possible to connect in with us, and it's possible to give some more support beyond. Anyway, mate, I hope you and I hope all the listeners today are having a wonderful time, and we've done an hour and a half or something of shows here, so I hope that you can get a letter out and then it could be just a one-pager, and that you've listened to me and you've heard what the essence of this is, and keep it in the essence, and have a successful outcome.
Oh, happy face! I'm so happy now that you took the time and explained it so well. I am going to re-listen with the pad and paper and draw up a couple of drafts, and maybe I'll send it your way to see what you think of what I put together. And then I also would love to go back to our previous video and maybe set up a few videos in a row that kind of like explain everything. Now, I have a particular situation with my children, but do you think this video would be useful for people who don't maybe have the exact situation, but could use the common law to in some in their own life?
Well, yes, that's true. This is a similar condition, really. The same thing has occurred wherever anybody is with your property, whether it's your children or it's your house. Property really is what's exclusively kept to be yours for your exclusive enjoyment beyond the other members of the society where you are. That's what the definition of property is. Though things could be different in some ways, it's not. What's similar and what's really common is a common law trespass on your trade name and fraud in de facto by forgery, you see,
Okay. So
and then everyone is being brought out because of this, so this is a way for you forward, because it is property, your all cap self which you own the all cap self of your children until that they reach a certain age, and you're the executrix or the executor of their estate. And no one has a right to take that from you, you see. So, no matter what is going on, it doesn't matter. All the other stuff, it's all sort of other stuff, but this, which is what's a primary common denominator. And I think that the more you can cut through the slack and just have a simple common denominator here, the better.
Okay.
And just less controversy and more simplicity.